Okay, today we're doing a deep dive into a really foundational piece of South African law. We're looking at the South African Social Security Agency Act, Act 9 of 2004. Now, this might sound a bit dry, but honestly, this law fundamentally reshaped how social welfare works in the country.
It absolutely did. Before this act, you had social grant administration scattered across the 9 provinces. It was quite fragmented. So our mission today is really to unpack how this one law pulled everything together, creating SASSA. But it wasn't just about creating an agency. It also put some very strict legal and, importantly, ethical constraints on it.
And the timeline tells part of that story, doesn't it? The act was assented to, signed off, May 2004. But Section 4, the part outlining the main functions, that only commenced April 1st, 2006.
Yeah, that nearly 2-year gap is significant. It wasn't just bureaucratic delay, It really points to the sheer scale of the challenge. Think about it. Moving millions of beneficiaries, billions of rand, from 9 different systems into one national agency. They had to build the ship while sailing it, essentially, ensuring nobody missed a payment in the process.
And the why behind it all, the legal driver, is laid out right in the preamble. It links directly back to the 1996 Constitution.
Exactly. The Constitution guarantees everyone the right to access Social Security. So the state has this obligation, not just a choice, but an obligation to take reasonable steps towards the progressive realization of these rights, even with limited resources. The SASSA Act became Parliament's main vehicle for doing that.
Aiming for what? Uniformity, efficiency.
Both, really.
Yeah.
The old provincial system was, well, potentially inefficient and definitely fragmented. The Act aimed for uniform norms, standards, a single delivery mechanism, and making sure those limited resources were used effectively and economically. Standardization was key to avoid inconsistencies that could disadvantage people just based on where they lived.
Okay, so let's look at the structure they actually built. Section 2 establishes SASSA, the agency itself, as a juristic person. For listeners maybe not familiar with that term, what does that practically mean?
Right, so being a juristic person means SASSA has its own legal identity, separate from government departments. It can enter into contracts in its own name, it can own assets, and critically, it can sue and be sued. It gives it a degree of operational autonomy.
But not total freedom, I assume? What about oversight?
No, definitely not total freedom. The checks are there right away. The Act makes SASSA subject to the Public Finance Management Act, the PFMA. That means rigorous financial scrutiny, budgets, spending, controls. It's all under the microscope from the get-go.
Before we dive into what SASSA does day to day, Chapter 1 defines some key terms: Social Security, social assistance, social insurance. What's the difference?
Yeah, that distinction is really important for understanding SASSA's role. Social Security is the big umbrella term. It covers everything. Social assistance is what SASSA primarily handles right now. Think non-contributory grants, child support, old age pensions defined in the Social Assistance Act.
Meaning you don't have to have paid into a fund to receive them.
Correct. That's different from social insurance, which is usually contribution-based, like, say, unemployment insurance funds. And Section 3, which outlines SASSA's objectives, reflects this split.
So it sounds like there's an immediate job and maybe a future one.
Exactly. The primary immediate role was to become the sole agent for managing and paying social assistance. That was the big centralization push. But the Act also gives it a perspective, a future role, to potentially serve as an agent for administering all Social Security, which could include those insurance aspects down the line. So they built a framework that could expand.
Okay, so we know its legal status, its scope. What about the actual day-to-day functions? Section 4 gets into the operational side. What's the core task beyond just processing grants?
Well, arguably the most critical function, beyond the administration itself, is the creation and maintenance of a national database. This isn't just like a list of names. It's a massive undertaking, collecting, managing, securing all the information needed for payments, for reconciliation, for managing the huge sums of money transferred. It's the tech backbone, really. And it's crucial for tackling fraud.
And that anti-fraud part is mandatory, isn't it? SASSA has to set up compliance and fraud mechanisms.
Non-negotiable. Given the public funds involved, it has to be. But here's where it gets interesting, that tension we mentioned. Section 4.2 allows SASSA to contract out parts of the payment process to third parties.
Right. Often private companies handling cash pay points or electronic transfers.
Exactly. So the state delegates the actual delivery sometimes.
But doesn't that introduce risks? How does the law ensure these companies prioritize people over profit?
This is where Section 4.3 is incredibly specific. It dictates mandatory clauses that must be in those contracts. Yes, efficient and economic use of funds is required, but so is the promotion and protection of the human dignity of applicants and beneficiaries.
Wow. Legislating for dignity in a service delivery contract? That feels significant. Does it have teeth?
It does. The contract must also demand honest, impartial, fair service delivery, protect confidential information, and, crucially, it must include financial penalties for noncompliance. So if a contractor fails on these fronts, especially on dignity or fair treatment, the law provides a lever to penalize them financially. It builds ethics right into the operational contract.
Let's shift to the governance structure then, chapters 3 and 4. There's a CEO appointed by the minister, 5-year term, renewable once, but the ultimate accountability seems very high up.
It really does. The CEO manages the agency day-to-day, sure, but Section 7.7 contains a pretty powerful clause. The minister may override any decision taken by the chief executive officer.
Hang on. If the minister can just override the CEO, what does that do to the idea of SASSA being an independent juristic person?
It's a strong check, definitely. It centralizes ultimate control within the political executive. It ensures that the agency, despite its operational autonomy, stays aligned with the government's broader social welfare policy and strategy. It prevents the agency from sort of going rogue or deviating from the minister's mandate. It's a very direct line of accountability.
And this tight oversight seems mirrored in the rules for staff, too. Section 8 is strict on conflicts of interest.
Absolutely necessary. Staff handle incredibly sensitive personal data and huge amounts of money, so they must declare any potential conflicts when appointed. They're barred from discussions where they have an interest, and critically, they can't use their position or inside info for personal gain or to improperly benefit someone else. Breaching this isn't just an internal matter. It often triggers serious consequences under the PFMA as well.
And the money itself. Funding comes from Parliament, grants, approved donations, fairly standard.
Yes, but the key safeguard is the auditing. SASSA's books aren't just audited. They must be audited annually by the Auditor General. That's a high level of independent external scrutiny, ensuring accountability back to Parliament and the public for how every cent is managed.
Okay, moving towards the end of the Act. Chapter 5 deals with legal safeguards. Section 16 focuses on protecting confidential information. How strong is that protection?
It's extremely strong on paper. The default is absolute confidentiality. No one involved can disclose information submitted for an application or payment unless there's a court order or the applicant gives written consent. It's vital for protecting vulnerable people and, again, ties back to upholding dignity.
And if someone does breach that or commits fraud, like pretending to be a SASSA official or taking bribes?
The penalties are severe. Sections 18 and 19 outline specific offenses, and Section 20 lays down the potential punishment, a fine or imprisonment for up to 15 years.
15 years? That's a significant sentence, especially for what might be seen as white-collar crime. It sends a strong message.
It really does. It reflects just how seriously the legislature viewed any attempt to defraud the social welfare system. Because stealing from these funds directly harms the most vulnerable people in society. The penalty underlines the gravity.
Finally, let's circle back to Chapter 6, the transition. We talked about the gap before the functions kicked in. This chapter dealt with the practicalities of that massive shift.
Yeah, this was the real heavy lifting, institutionally speaking, transferring all the assets, liabilities, funds, and crucially, thousands of staff from the 9 provincial administrations into the new national SASSA. That staff transfer alone had to be handled very carefully under the Labor Relations Act and existing agreements.
But the standout clause for me, the one that really shows the intent, is Section 24C. What did it demand regarding the beneficiaries during all this change?
That's the one. It mandated that the minister had to ensure the entire transition process did not in any way cause discomfort, stress, or an interruption or decrease of payments to recipients. Just think about the pressure of that. While undertaking this huge, complex merger, the absolute priority defined in law was the uninterrupted well-being of the beneficiaries. Human impact first.
So success wasn't just merging the systems, it was doing it so seamlessly that the person relying on that grant barely noticed the massive administrative change happening behind the scenes.
That was the goal. Eliminate the fragmentation and inefficiency at the structural level, but never, ever at the expense of the individual's lifeline.
Okay, so pulling this all together from our deep dive, what should you, listening, take away from the SASSA Act of 2004? It clearly represents this major consolidation, creating one national body, SASSA, to handle social assistance.
Right. It builds a strong, centralized bureaucratic structure. You've got the ministerial override, the national database, the Auditor General audits, all geared towards control and efficiency. But at the same time, it layered in these really strong ethical requirements. That dignity clause in contracts, for instance, and the severe penalties for fraud or misconduct.
It really highlights that tension we've tracked, the need for strict, efficient administration versus the legal mandate to treat people with dignity.
Which leaves us with a final thought for you to mull over. When you design a system primarily for mass administration, efficiency, and preventing fraud, how effective can those softer legal mandates, like protecting human dignity in a contract clause, actually be in practice? Can a highly bureaucratic system be genuinely compelled by law to be human-centered, or does the drive for control inevitably overshadow the compassionate intent? That's the ongoing challenge, isn't it?